Debtor versus Wells Fargo et al. Motion to dismiss complaint filed by defendant.
Andrew Bailey appearing telephonically. Good morning, Your Honor.
This is John DeStefano and Andrew Hardenbrook on behalf of Wells Fargo Bank and U.S. Bank.
Defendant's motion.
No, Your Honor, Wells Fargo and U.S. Bank's motion. We're the defendants, yes, motion to dismiss.
Okay. I'm generally familiar with the motion. I'm happy to hear anything you want to add to it.
Good morning, Your Honor. I understand the court is familiar with the motion, and we would submit that our arguments rest principally on the briefs. I would simply add that as to plaintiff's challenges to standing or general authority to foreclose, this is really the third time that the court has been confronted with these very same objections, and I would argue that they were submitted already in the context of the initial motion for release from stay, and the subsequent motion for reconsideration, and the motion to vacate the stay relief order. That this adversary proceeding is another attempt to obstruct the foreclosure, wherein plaintiff has actually taken on a higher pleading burden, which he cannot meet. The court has already noted how plaintiff's objections are essentially speculative, allegations of fraud and other wrongdoing, and under the applicable Rule 12 standard, there's no way for this adversary proceeding to go forward on simple suspicions and implausible allegations. So with that, barring any questions from the court, I would reserve my time for rebuttal.
No questions. Mr. Bailey, your turn.
Good morning, Your Honor. A number of points here. One is that one of the defendants involved in the securitization of the loan, that's Lehman Brothers Bank, is missing from this action. I don't quite know why or how, but Lehman seems to have dropped out. And of course, Lehman is in bankruptcy, and as a participant in this entire process, it would seem that there's something significant there. I'd just like to note that. Secondly, I suspect that there's a conflict of interest in the simultaneous representation by counsel. Counsel appears to be representing both Wells Fargo and U.S. Bank, and my understanding is they cannot represent both. Now, with regard to standing, my contention is that neither party ever proved that it had standing or authority to initiate and sustain a non-judicial foreclosure action. Secondly, we're in litigation from the moment of my objection, and therefore I maintain that it's no longer a non-judicial foreclosure. The non-judicial foreclosure statute does not apply. And therefore, this proceeding here has nothing to do with the automatic stay. Whether the automatic stay was granted is a moot point. Now, with regard to standing and status, previous counsel, Tiffany and Bosco, for Wells Fargo, has admitted to misrepresenting its status in this court. They falsely claimed to be the current beneficiary at both preliminary hearings, but claimed that that was a fact of no consequence. They admitted it was a fact, but they said it had no consequence. Counsel claimed inadvertency, which was impossible. I had provided certified letters which they had received. However, Wells now claims authority based on the alleged limited power of attorney from U.S. Bank. That document simply does not stand up to close scrutiny. U.S. Bank neither asserts any authority nor confers any authority on Wells Fargo to do anything. So my position is that limited power of authority does not have any effect. So with regard to standing, I assert that the parties did not have standing to bring the foreclosure action, which has resulted, of course, in the lift of stay. So I feel there's something wrong there. My fraud allegations, the one that I feel the strongest about is that this loan is a classic example of predatory lending, which is fraud. Wells bypassed its own underwriting standards for its own reasons, knowing full well that the borrower could not repay the loan, and therefore that Wells would gain title to the collateral, namely my home. Finally, I would state that I stand by each of my allegations as pled in my second amended complaint, and I will stand down at this point. Thank you, Your Honor.
Thank you. is an appropriate form of order. Thank you.
The decision was made before any. I mean, his decision was just right there. It had nothing to do with anything, right? Nothing was debatable. Nothing could be discussed. He'd made up his mind. Whose side is this judge on? Any idea?
Wow.
So there. That would.
That is an insult. That was an insult.
You'd say that's an insult?
Yes.
You mean the judge is insulting the plaintiff?
Yeah.
Yeah.
He didn't thank you for your comment. He didn't thank you for your comment. He didn't acknowledge you. That motherfucker. He did not even acknowledge you. He said, "Good morning, Judge."
Yeah.
He did not say, "Good morning, Mr. Bailey."
Right.
Wow.
You'd think at least there'd be some gentlemanly interaction without any
That's insane.
any actual rudeness. You would say that's actually an insult on the part of a United States bankruptcy judge.
That
and
is
so
that's an insult.
that's an insult. Cool.
Do you feel insulted?
Well,
Negated? Insulted?
yeah.
That was a hearing.
You know, that was a hearing. It lasted 10 seconds. He'd already made up his mind. There was nothing to be said or done, nothing that I could have said or done or prepared for or whatever. All of these papers might be meaningless, huh? So, makes you wonder about the justice system and whether one can actually expect justice. What was it the U.S. trustee gentleman said to us? You can believe in truth all you want, but do not expect justice. Okay, now I know my eyes have been over at you, and I'm not sure what that's meant to be, but that's okay. So, if I am to understand that correctly, that was the third and final amended complaint on 3 different properties that have been bam, 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 dismissed. Did he say with prejudice or without prejudice?
He didn't say.
He didn't say. But then when they put their order and they put it in with prejudice, which means you cannot come back. You're done, you're out. Which means we're basically out of the bankruptcy system at this point. The bankruptcy courts have not been helpful to us. There are many lawyers who say your best place is in the bankruptcy court, and apparently not. So now we're in state court on one of the properties, and that actually feels good. Feels like we have a judge who is listening, a judge who is interested, who's engaged, who's honest, who's unbiased. It feels that way. Time will tell. You know? Because my attitude is that if they truly have the right, these banks, to foreclose on these properties and take these properties, fine. I don't have a problem with that. I do have a problem if they do not, if they're criminals, and it appears to be the whole banking system appears to be a criminal enterprise. Wall Street appears to be a criminal enterprise in collusion with not only the banks, but the judges. It's like the cops and the robbers got together. The cops, the enforcers, and the robbers, the banks and Wall Street, have now joined forces. Now we can call them Cops and Robbers, Inc. How about that? Cops and Robbers, Inc. Versus the people. And we, the people, are being versused. What does that mean? We're up against it. We're up against a very big, very well-funded monster that wrote the laws in the first place. And they pay the salaries of the people who enforce them, ultimately. We think we do, but in fact it probably turned out to be them. And I'm also told that back behind the scenes, every time they get a decision like this, a little enhancement occurs at the level of the retirement fund in some bank somewhere. Don't know if that's true, but I was told that. And listen to all these conspiracies and conspiracies. So there you are. Today is what date? It is
July 22nd.
Thursday, July 22nd. Thursday, July 22nd, 2010. And here we are at the Institute at Sedona, where we actually have not paid a penny in mortgages for over 2 years, where this property where we are sitting right now was actually sold at foreclosure sale back in May. This is July, so it's May, June, July, almost 2 months since the sale. We're still here. We're in court. We're now in state superior court, claiming that they have no right to have sold the property, that it was an improper sale. So we shall see. Good job, girl. Thanks.
We should